What's up, everybody, and welcome back in. We're talking Brian Kohberger because the Idaho Supreme Court has rendered its opinion on whether or not Brian Kohberger is going to be able to pause this case, appeal issues that happened during the grand jury proceedings, whether the burden of proof should be beyond a reasonable doubt versus probable cause, whether or not the prosecutor withheld exculpatory evidence or there was any prosecutorial misconduct at all during the grand jury proceedings. We get the answer from the court. We don't get a lot of details, but I think we can learn from what the court said in their order. And we're going to talk about whether or not this affects his opportunity to appeal these same issues later and whether or not the court's decision has any bearing or says anything about the merits of his argument at this point, or is it purely procedural? And to help me answer those questions, I've got my dad on here with me. Hello, Father.
Hey, how are you?
Oh, I'm doing great.
How was your trip?
It was great. It was fun. We're back. It was way too early to get up to fly home today, but we made it. Saw a lot of legal stuff there. Maybe we'll do a video at some point. Supreme Court, Court of Appeals, lawyers everywhere that ended up becoming president. So it was cool. Documents, things like that. But we have this interesting thing going on in the Brian Kohberger case. We've talked about it before, and we're going to link our video where we actually talked about the appeal itself, what they were appealing, what we thought was going to happen, our predictions, things like that. We'll link that video in the description if you want to check that out, because we're not going to dive too deep into that. We're going to focus on the court's order and what it means for the case now and what it means for these arguments that Brian Kohberger and his team made. So let's start out by bringing up the order, and we will read it together. If you can't see it on the screen, that's okay. It might be a little blurry. I'm going to read it here. It is the order denying the motion for permission to appeal from interlocutory orders. A motion for permission to appeal from interlocutory orders and a motion to seal defendant's motion for permission to appeal from interlocutory orders were filed by counsel for the defendant on February 8th, 2024. So they've turned this around in a month, which is a pretty good timeline, if you ask me. I'll get your thoughts on that in a minute. In objection to the motion for permission to appeal from the interlocutory orders and a motion to seal plaintiff's objection to the motion for permission to appeal from interlocutory orders were filed by counsel for the plaintiff, which is the state of Idaho, as you can see above in the case header, on February 20th. Therefore, after due consideration, and then we get the order. By the way, February 20th, that's less than a month. That's like 2 weeks, maybe 3 weeks. And the Supreme Court of this state has answered. That's how seriously they're taking this case and how everybody's making sure there's no delays. What's the order? It is ordered that the defendant's motion to seal, defendant's motion for permission to appeal from interlocutory orders, and plaintiff's motion to seal, motion for permission to appeal from interlocutory orders are granted. It's like, what? It says denied at the top. What's granted? Well, all this mumbo jumbo basically means that the court is granting the sealing of these motions, not the motions themselves, just to seal them from the public. Because then if we read the last paragraph, it is further ordered that defendant's motion for permission to appeal from interlocutory orders is denied. So the big one is denied, and we're going to talk about these in turn. First, let's talk about the timing data. Are you surprised with how quick this decision came down?
I am. This is grease lightning for an appellate court. And I think with this appellate court, Supreme Court, for any appellate court,
right, exactly.
Any court, it's grease lightning. And I think what they've recognized is this is not going to be the last time that there's going to be an interlocutory appeal in this case, that there's going to be one after the other, and they're establishing a precedent that, filing these motions is not going to delay this trial. They're going to shoot an order out as fast as they possibly can to keep this case moving.
And in a hearing prior, the last hearing, they said they were going to keep the case moving even while they were waiting for the Supreme Court's order. So they weren't pausing the case right now. They're still doing discovery, still having hearings, still moving the case along. Right. But the Supreme Court just wanted to move it along as quickly as the trial court because everybody wants this case to go to trial. We're looking at summer of 2025, potentially maybe March of 2025 at the earliest for this trial date. So the Supreme Court didn't want to be a reason for delay. And let's start with the motion to seal. That's the easier one. And we'll wait for the denial of the actual motion or the actual motion to have their appeal heard. So the motion to seal. So what's interesting is Kohberger filed this motion to have an appeal heard. It was denied. but they also wanted to seal it. So the details of it, which include grand jury proceedings, things that happen in the grand jury that are secret, that motion to seal is granted. So nobody's going to be able to see this motion to have the appeal heard from Kohberger. The state filed their objection, which is their response. They also filed a motion to seal their response. But the court granted a motion to seal Kohberger's motion and then granted the state's motion to seal Kohberger's motion instead of the state's objection, which I think is probably a typo, but could have some ramifications if the state's objection becomes public, right?
Right. Yeah, I'm sure that they put something in their objections that was part of the secret process. Because again, looking back, this is kind of a double secret process. You have the grand jury materials, but you also had an out of the public view in camera hearing on this case that no one knows what happened back at that hearing except for the lawyers and the judge. So that's secret. The grand jury material is secret. And if you go back to June when the original order that allowed the material to be released to the lawyers, there even was called an Exhibit A to that. That was also secret. So you've got 3 or 4 levels of secrecy in this, and none of this should come out. And the Supreme Court recognized that and made sure that everything was kept under wraps.
So what do you do in a situation like this when maybe there was a Scrivener's error, typographical error, where the court sealed something twice instead of sealing 2 different documents? What can the state do?
Well, they can file a motion saying that there was a Scrivener's error. Sometimes you even can be a little more informal. You can call the law clerk or the clerk of the court, and you can say, guys, I think you need to take another look at this order because I think there was a mistake. And even that kind of an informal contact, that sometimes will produce a correction. Again, this is obviously just a Scrivener's error.
Probably. I shouldn't say obviously. I don't know what they're going to do. Maybe they did it this way on purpose. We think it's probably some kind of error because they probably do want, the Supreme Court, I would think, would want to seal the state's objection. If there's any, I mean, if the state thinks that there's been something in their objection that should be sealed throughout this case, everything that has been requested to be sealed has been sealed.
Right. You're right. We're presuming something we don't know, but I'm presuming it.
Right.
Yes.
Right. Okay. So everything is probably going to be sealed. Before we get to Kohberger, the answer on that denial, the state filed an objection. Why was there no answer on the objection? Because we only have orders on the 2 motions to seal and then Kohberger's motion. There was no order on the state's objection. Can we assume they won since Kohberger's motion was denied? Is it just a moot point at this point? Why don't we have the court granting the state's objection as they deny Kohberger's motion?
Well, appellate courts don't do anything that they don't have to do. And when they issued the order on Kohberger's motion, that kind of took care of probably any of the objections that the state had. So there wasn't any reason to go into those objections. Again, the only thing they should have done is done the sealing, but they didn't see any need to answer those objections since they'd already taken care of it. Remember, we covered this type of appeal on an earlier video, and because this does not stay the proceedings, there was no need for them to actually take any action.
Is there anything wrong with the Supreme Court not giving the reasoning for denying Kohberger's motion here? Because there really is no reasoning in the order. Is there anything problematic about that?
They do it all the time. We call it per curiam. But you know, they issue orders all the time without giving their reasons. And in this case, they didn't see any need to give a reason. They just disposed of it. I think that they're realizing they may see this in the future. So there's no reason for them to pin themselves down now with a reason.
So, and that could be one of the other reasons why we don't hear anything about the state's objection, because maybe we're in the dark here, right? So there's a lot of guessing going on because we don't even know what the state's objection was. It could have been procedural. It could have been substantive. We don't know what their objection was, but if they would have granted the state's objection, maybe that would have been a reason for denying the defendant's motion, and they didn't want to grant the state's objection because then somebody could read into it that was the reason they denied the defendant's objection, when they could have just denied the defendant's objection or defendant's motion to have their appeal heard for a procedural issue, or because they didn't think it was extraordinary enough, or because they didn't think the merits were strong enough. Whatever it may be, it doesn't really matter. The fact that they're going to deny it just means the state or the case is not going to pause. Everything is not going to come to a screeching halt, right? So go ahead.
It's the safest way for the Supreme Court to proceed is to not say anything.
Right. But I think that from our perspective, it's important to point out a few things. Number one, the interlocutory appeal, meaning stop everything. Let's handle this appeal right now. Supreme Court, make the decision, throw out this indictment, is only for extraordinary and exceptional circumstances. It is not the norm. It is the exception to the rule. However, do you think that the merits to an argument affect the chances or the likelihood of it getting taken up on appeal? What I mean by that is, if the defense would have had a stronger argument, would it have been more likely that the Supreme Court would have said, yes, we're going to take a look at this now?
Well, I do. The Supreme Court always looks at facts. They always looks at what really happened here. And if there was really something they wanted to put their fingers in, they can. They've got the ability. They've got the authority. They can do whatever they want. So they just felt like this is not the right time or place to get into this argument, and they pushed it off to what would be a later hearing.
Yeah, and I think that it's kind of multiple ways to look at this, but timing wise, it makes sense why they would want to file this interlocutory appeal, or why they'd want to pause it, because we don't want to go through the whole case. We don't want to go through a trial, maybe a conviction, and then have to appeal it then, where it's much harder. If we can get it thrown out right now, it doesn't mean Brian Kohberger goes home free. It just means the state has to either do another grand jury hearing, or they have to do a preliminary hearing where they present the evidence and the defense gets to be involved in that process and kind of push back. So that was the only real win that would have come from this. It wouldn't have been, this case is over, Brian Kohberger goes home. So it makes sense about the timing, why the defense thought it was important enough to argue now. But what are your personal thoughts on the merits of the arguments they wanted to bring up on appeal?
I think they're absurd. The trial court called them creative. When the trial court, I listened to the judge call them creative, but they're not creative. They're absurd. There is no case law. There is no authority for instance, it should be beyond a reasonable doubt than probable cause. That's just an absurd argument. There's no grand jury in the world that I know of that goes beyond a reasonable doubt. So you have probable cause. It's established for hundreds of years in the case law. They're throwing this out. And again, it's an absurd argument. Prosecutorial misconduct. You have to really, really be bad to have prosecutorial misconduct, and it has to be intentional misconduct. The fact that they didn't put exculpatory evidence on, there is no requirement that they put exculpatory evidence in a grand jury. All of these arguments are arguments that really are weak at this point. Now, maybe later on, things come out that are more significant. The fact that a grand jury is biased, those kind of things, that's almost impossible to prove. And you certainly, no one thought they have any evidence that it was biased. The judge said it was a totally unbiased jury in his review of the documents, which again, we don't see. But I just don't think there's any merit, at least at this point. I don't see any merit to any of their arguments. I don't see how the Supreme Court, let's face it, they had no problem with it. In a month, they disposed of it.
Yeah, I agree with like 99% of what you said, not necessarily everything. I do think there's some prosecutorial misconduct or things like that that could have risen to the level to allow this with the way and what they presented. But the standard of proof, the biased jury, all that stuff was never going to win. It was never going to have a chance to win. And one of the reasons it's so hard for something like this to win is it has to be so bad, number one, that the Supreme Court's like, let's pause everything and waste a bunch of time and money redoing all of this. And it has to be so bad, plus the trial court judge missed it or disagreed with the defense and what the Supreme Court is going to do, which is why it's so unusual and usually very unlikely, although not impossible. That's the point of having this as an option for extraordinary circumstances. And, in some cases where we do see this, there are problematic judges. There are biased judges sometimes that allow certain things to happen that they shouldn't. And the Supreme Court is there to make sure that type of stuff doesn't get through. But as we're looking at this, I think, the way you and I see it, there's not a lot of merit to any of the arguments we know about. We don't know about all the arguments because, half of it was sealed, probably more than half of it was sealed. But the burden of proof stuff or the standard of proof, that's just a weak argument. And, both of us think the Supreme Court, if they thought it was a strong argument, they might have taken a look at it. But even after saying all that, does that mean the Supreme Court of Idaho at this point has denied their argument about the standard of proof and prosecutorial misconduct? Have they made that decision that there is no merit to that argument and they're denying that appellate argument right now?
They didn't say it, so we're speculating about what happened. They get together in a conference and they talk about these things, and we're speculating what happened in that conference of the Supreme Court, the justices of the Supreme Court. But I would think they've disposed of it. I would think if
Well,
they thought there was, if they really thought there was prosecutorial misconduct, I really think that they might have gone, and it might have taken more than a month for them to come out with this order.
but what you're saying is you think we both agree that they don't think it has merit, but they have not disposed of it because Kohberger can still file this appeal after the trial, right?
Oh, yes. Oh, yeah.
He can still make these same arguments, right?
Oh, yes.
You're fine. You're fine.
Yeah.
What-
Yes,
what
they
are you doing with
absolutely
the
can.
camera?
What?
Well, you were just shaking your camera. Is it fine?
Oh, I had to plug it in so it didn't
Okay.
die.
So,
Um,
but so practically speaking, they can still make this argument again. It has not actually and legally been disposed of. That's what I meant. In their head, sure. The way we look at it, we're reading between the lines. They don't think it has a lot of merit, or they would have looked at it more. They maybe would have heard arguments on it. They would have let both sides brief it. They could have done it now. And even on top of that, if they thought this was merit, they should want to handle it now, right? If this was a meritorious claim that this stuff that happened in the grand jury was so wrong, they'd much rather handle it now than after trial where even more time and money is wasted, right?
That's very logical, and logic would make you think that, yes.
And that's why you're saying you think they've disposed of it, but legally
Yes.
speaking, he can still make these same exact arguments on a post-trial appeal.
Right. We've got to keep in mind, and we don't want to lose sight of the fact that although there's a lot of publicity, although it was a horrendous crime, it is a murder. Not the first murder case that has ever come to before this judge, and not the first murder case that ever come before this Supreme Court. So, they're handling it like they would handle any other murder, that they wanted to go forward. And these arguments on murder cases are made all the time.
Right. And I think that that's kind of what means that the stuff that's like an easy throw out would apply to every case that deals with murder. But the stuff that's not is the biased grand jury potentially would be different with this case than other cases just because of the publicity. If it existed, I'm not saying it existed, but that could be a different argument. And then the type of evidence or prosecutorial misconduct because they want to make sure they get it right. I do think that could be different than some other murder cases potentially that this court and the Supreme Court have dealt with in the past. But so this does not prohibit them from appealing this in the future. It doesn't prohibit them from making these same exact arguments, even though we don't think they're meritorious. If nothing better comes up throughout the trial process, and this may be all they have to rely on. But if you were handling this case, if you were the defense attorney on this case and you filed this motion to have this appeal heard, to pause the case, and they got all the information that you briefed and they denied it this quickly, would you automatically think this is a good argument and force it into your appeal? Or would you try to find other arguments that you don't already kind of know they don't like as the Supreme Court?
I would try to find other arguments as well. I wouldn't waive these. I mean, these arguments will still come up, I think, in the final appeal when the case is over, if he's found guilty. It'll still come up, but I certainly would find other arguments other than these. These would certainly not be my first choice.
Right. So it's like you have them, you've briefed them, you know them, it could be an issue. But the other reason why I don't love these arguments as a defense attorney is they don't really give you the win that you want, right? Something happens where you can, get him to go home and actually win the case outright or prove his innocence or something in some appeal with DNA testing or whatever. That's obviously your number one argument. Just redoing all of this, while a very common remedy to most criminal appellate issues is a new trial, this would be a new preliminary hearing or grand jury proceeding and then a new trial. If you can find other better arguments, you always look for them, but they already have these briefed. They already have these ready. I would be surprised. It sounds like you would be surprised if they were meritorious at any point throughout this case.
Absolutely.
All right. So that pretty much, was there anything else you wanted to hit on this order?
Well, I said you've commented on the speed, and that's something that no one should ignore, is how fast this went, because I think we're going to see this repeatedly in this case. I think the Supreme Court is ready to move quickly on any of these. And as we've talked on prior videos, this defense team is trying anything and everything, which they should do because they have a man's life in their hands. And this is just par for the course. They found something, they're trying it, and they're doing everything they can.
I do have one more question for you then. So in this process, if you find yourself filing multiple requests to have an interlocutory appeal heard like this request, and they keep getting denied, does that make you less likely to file the next one? Or are you just going to continue to file, continue to get denied? Because this is not necessarily something you have to do to protect the record. We talk all the time about you got to protect the record, you got to protect the record, you got to protect the record. Filing and asking the Supreme Court to look at something in the middle of a case is not something you have to do to protect the record. You object, you file your motion to compel, you have your argument, the judge makes a ruling, you bring it up again at trial. You protect the record that way, not necessarily by asking for another interlocutory appeal. So if you think they're going to do it multiple times, would continuing to lose discourage a defense attorney to not do it as often? Or how does that come into the analysis now that they've already lost once?
Hey, what's happened's happened. It's in the past, and you don't even think about it. They move on to the next one. I think you'll see this happen repeatedly, and being denied is not going to affect how they defend this case.
How do you determine whether or not you want to file it to be heard right away? Is it something that, because everything you feel like is a big deal, and you'd rather have it heard before, like I think in Michigan, they had the argument, the school shooter's parents who are on trial right now, the Supreme Court did hear arguments about whether or not it's even lawful that a parent could be charged with involuntary manslaughter based on their child school shooting. And the Michigan Supreme Court looked at it and said, yes, that was important enough as a legal issue to determine before obviously they were tried and potentially convicted. Like one of them has already been convicted, maybe two by the time this video comes out. But basically you're saying if you feel like it has merit and it's an exceptional circumstance, you would still file it every single time, even if you lost 10 in a row.
Absolutely.
It's pretty much what
Every
criminal
time.
defense attorneys do and are used to doing.
That's right. And you know what else? Losing doesn't affect us. We just move on to the next argument because, we get overruled, judges overrule us, but we fight.
You only need one to work, right?
That's right.
All right. Well, that's everything we've got on this appeal. Thank you, everybody, for watching and listening. Until next time, we are out of here. Thanks, Dad, for joining us. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.